Hi everyone, welcome. So today we are going to be talking about if you can get parole in place, the new Biden administration program, if you have a removal order, if you have a deportation order, what does that actually look like for you? So we're going to be talking about that today. If you have questions, as always, put them in the comments. If you're watching this on the replay and you have questions, put them in the comments as well. If you're new here, I am attorney Lillian Chukura. I help my clients get green cards and citizenship for themselves and their families using the U.S. immigration law system. I have been an immigration lawyer for almost 10 years now. So when I talk about immigration, this is something I'm very passionate about, and I want you to have all the information. There's so much misinformation out there when it comes to this particular program. So I want to give you all the information so that you do not end up applying for something you don't qualify for and ending up in more trouble than you currently are. Okay. So who can actually apply for this? Spouses of U.S. citizens that have been in the U.S. for 10 years as of June 17, 2024, right? Are the ones that qualify for this. So if you have been here for that long, you were married to a U.S. citizen as of that date, and you don't have any disqualifying crimes or situations, you can qualify for this program and apply for this program. Now, one of the things that can disqualify you when it comes to this program is having a removal order, having a deportation order that has been executed. Okay? Having a deportation order that has been executed automatically makes you ineligible, means you cannot apply for this. So I'll explain what executed versus unexecuted means, because if you have an unexecuted removal order, you may be able to still apply for this program. You just have to show more things than someone that does not have a removal order. Okay. So first off, let's start with the difference between executed and unexecuted. So when you are in immigration court, you go in front of the judge, you plead your case. If the judge finds you deportable, they will order you to be deported. You may appeal the case, but now you have a deportation order. If you leave the U.S. based on that deportation order, or if the government makes you leave the US, like physically deports you from the US, you now have an executed removal order. So I just want to make that clear. It's about if you left the US after you got that deportation order. If you never left the US, you have an unexecuted removal order, because you have to actually leave the US for that order to be executed. So if you have an executed removal order, meaning you got your deportation order from the court and you left the US, or you had an expedited removal at the airport, at the port of entry, and you left. In those two situations, you now have an executed removal order. And according to this program, if you have an executed removal order, you are not able to apply for it. Period. Like there's no exceptions when it comes to that. Executed removal orders do not have an exception to it. There's no presumption of anything. It's just you're not eligible. Okay. However, if you have an unexecuted removal order, there's a presumption that you are not eligible. Okay, the US government, when they get your application and they see that you have an unexecuted removal order, meaning you were ordered deported and you never left, if they see that, they can basically assume that you don't qualify unless they see something in your application that makes them change their mind, basically. So they see your application, they assume you don't qualify unless you can show them that there's a reason for them to change their mind. So it's really important that you figure out which camp you fit into, if it's an executed versus unexecuted. If you are physically in the US and you have a deportation order from the court, if you have an in absentia order of removal, and you never left the US, then you most likely have an unexecuted removal order. Okay. And that's really, again, that's really important because that's what they're looking at. Is it executed or not? So if it is not executed, right, an unexecuted removal order means you can apply for this program, but you have to show extra things to basically overcome the presumption that you do not qualify. So the things that they look at when it comes to can you overcome this presumption, right? They say rebut the presumption, but they really mean can you overcome this? Is there something in your file that's enough for us to say, you know what? The rule says you don't qualify, but we can make an exception for you. Okay, this is not like, oh, there's a blanket exception for anyone that meets these requirements. It's on a case-by-case basis. So why should they make a different decision on your case versus the next person that has an unexecuted removal order? That's really the way you should focus this when you are presenting documentation. So the things they are going to look at is what, if you have an in absentia order of removal, they're going to know why you didn't show up to court. Is it because you did not have notice of your hearing? Did did the court send your information to the wrong address? Things like that, right? So if you have a good argument as to why you didn't show up for court for an in absentia order of removal, they may still approve your PIP because of that. Okay, so they also are going to look at your age, right? The younger the person is, the better. So if you were a child when you got your removal order, that is going to be taken into account versus if you were an adult. They are also going to look at the language barriers. So if there's any language barriers that made it impossible for you to properly present your case, again, in your parole in place application, you need to document this. So you don't just say, oh, well, I wasn't able to go to court because of, I didn't get the notice, right? You should be able to document why you didn't get the notice. Was it sent to a different address? Were you never given like a proper notice to appear? Those are things that as an immigration lawyer, I know that in immigration court, if you have a notice to appear that does not have a date and time of when your court hearing is, we can request for your case to be terminated, right? We know that in immigration court context. So you can also use that same argument in this context to say you were not given proper notice of your hearing because there's no time and place on your notice to appear. The notice for the hearing was sent to the wrong address. You did a change of address, but they sent it to your previous address, right? Or you never got a notice of hearing, right? So those things are things that you can present. Also, if you have ineffective assistance of counsel argument, you can also use that as well. So present evidence of your prior counsel not following, the law, or we've had cases where the prior counsel filed fake applications and now is in jail because they were sued by the Attorney General. This was out of New York. So there may be cases where you meet the requirements for ineffective assistance of counsel, right? But you still need to document how was your counsel ineffective? What were they supposed to do and didn't do, right? So if they were supposed to file an application before in deadline and they did not file that application because of on that deadline, and you ended up being ordered removed because they did not file that application on time, and you can show you gave them everything to file the application, they just dropped the ball and did not file it on time, and that led to you being ordered removed. That's an example of a situation where you can make an argument for ineffective assistance of counsel and present that to USCIS to basically say, hey, I know I was ordered removed. I never left the US, so my order of removal is unexecuted. And the reason I even have an order of removal to start with is because my prior counsel was fraudulent, right? That my prior counsel did not do what they were supposed to do, what I paid them to do. And then there's also situations where you may not have worked with a lawyer, but you were defrauded by someone posing as a lawyer, right? Sometimes there's a notarial that is telling you, oh, you can file for X, Y, and Z, or all these other things. And they make you file things in court that is not actually proper for your case. If you can prove that you were a victim of that fraud, and show the connection between the fraud and your immigration case and your removal order, then that's another thing you can use to show that even though you have this presumption that you don't qualify, these are all the reasons that you still qualify. So it's really important that as you are going through your process, especially if you know you have a removal order, please, 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 schedule a consultation. Talk to a lawyer first, because you want to make sure that you do qualify before you file anything. And if you don't qualify, or if there's a presumption that you don't qualify, we can work together to figure out what is the best way to prove that you still qualify, right? What is the best way to document these exceptions so that USCIS can clearly see that even though you have a removal order, they should still, in your particular case, find that you still qualify. So removal order that's unexecuted, meaning you never left the US after you got that removal order, does not make you automatically disqualified. It just means there's a presumption that you do not qualify. So you just have to present documentation and evidence to basically change that presumption, to basically say, hey, I know you think I don't qualify and it looks like I don't qualify, but here's all the documentation, all this evidence that shows that I should still qualify for this program. Okay, and it's really important to document. You can put it in your affidavit and things like that, but you also want documentation to back it up. So sometimes people will talk about, oh, in their statement, they will say, I was defrauded by X, Y, and Z. They made me file this. I paid them this much. USCIS may want to see some form of paper trail that shows you did pay this person or that they were involved in your case, things like that. So you want to make sure that you are documenting all of it. And typically, if you come to me, we are going through every single requirement and seeing how we can make an argument, what documentation we can include to basically show that you still meet these requirements. All right. And then lastly, I want to talk about people that are currently in immigration court. Okay. When it says that you are not allowed to apply, like you are ineligible, they're talking about people with final removal orders, right? You already went through the court, the judge found you removable, you may have filed an appeal, or you missed your appeal deadline and your case is now final. All right. If your case is not final, this does not apply to you. So if you have, a court hearing next year, you can apply for parole in place if you meet the requirements. There's no presumption that you do not qualify because you do not have a final removal order yet. So that's really important. So if you're in immigration court and you are, afraid to apply because you think that you don't meet the requirements because they said something about removal orders, well, if you have hearings coming up, that means your case is not final yet. And if your case is not final, then you don't have a final removal order, which means you can apply for this parole in place, and there's no presumption that you don't qualify. Remember, the presumption is only if you have an unexecuted removal order, and then you're ineligible, completely not able to apply if you have an executed removal order. All right. So if you have a pending case in immigration court, you can still apply. If nothing else, just remember that. If your case is still pending and it's not final, there's no presumption. You can just apply if you meet the requirements. And then finally, if you have a permanent bar, okay? This is where it really gets tricky and where you should be meeting with a lawyer first before you file anything, okay? If you have a permanent bar, remember I said that if you left the US because of a removal order, you are ineligible. You are not able to apply for this. This also applies if you have a permanent bar. And the reason you have a permanent bar is because you had a removal order, you left the US, and then you came back to the US without inspection. If that's the reason you have a permanent bar, you're not eligible for this. Okay. If your reason for having a permanent bar is that you were in the US for over a year, you left the US, not because of deportation, right? You left the US on your own, and then you came back in without inspection. Technically, you should still qualify for this because, again, you do not have a final deportation order. However, you may want to talk to an immigration lawyer first to make sure that there's not other things to consider, because there may be risks that you want to consider first before you file anything, okay? With a lot of these applications, of course, there's going to be risks, but if you are already known to USCIS, if you are already known to US immigration in general, the risk is lower than if you have never had any interaction with US immigration, okay? So if they already know you're in the US, they already know where you live, your risk of applying is lower because they already know where you are if they wanted to come after you. That's what I mean, right? If they wanted to come after you, they already know where you are. If you have filed a 601A waiver, if you have filed an I-130 showing that you live in the US, USCIS knows where you are. So if you qualify for this parole, speak to an immigration lawyer and then make the decision of whether you want to apply for it or not. One thing I will tell you is if you have a 601A waiver that's pending or already approved, you already did your biometrics, remember that USCIS is giving those cases priority. So don't wait too long. That's all I'm going to say. Apply as soon as you have all your documentation showing the years in the US. And when it comes to showing the years in the US, just make sure you're not like overthinking it, okay? Don't overthink it. That leads to like months and months of you trying to get every single day, okay? No. You want enough documentation that it's more likely than not. So basically you want enough documentation that when USCIS looks at it, it is more likely than not that you were in the US for those years. Not that you are proven beyond a reasonable doubt that you were in the US. So those are two different things. Those are two different standards. So more likely than not is more like 51%, right? Not 100%. So think about it that way. So not every single month. If you're not able to get documentation for every single month, but you can get for like every 4 months. So every quarter, every 3 months, every 4 months, you have documentation to show for every single quarter, even if it's just one documentation, right? That can be enough. So just make sure you have all of that. And then for people that have the presumption that they are not eligible because they have that unexecuted removal order, you want to make sure that you are documenting everything when it comes to the reasons that you had that removal order. So if it's an in absentia one, remember I said you want to make sure that you are providing reasons why you did not show up. Okay, if you did not get notice, I lost my word there for a second. If you did not get notice of the hearing, either your notice to appear did not have a date and time, or you never got a notice of hearing in the mail, just have some proof of that. So typically, proof of that would be showing your notice to appear that does not have a date and time, showing if you can get a copy of your immigration file that shows where they sent your notice of hearing and that it was the wrong address, showing that you actually did a change of address with the court, but they sent it to an old address. Those type of things will help to basically rebut the presumption, overcome the presumption that you do not qualify. And then if you had ineffective assistance of counsel, your lawyer did not do what they were supposed to do, or the reason that your case was ordered deported is because of something your lawyer did, not something you did, you may want to document that as well. If you were a victim of fraud that led to your immigration case being deported, and that fraud had to do with your immigration case, then you want to document that as well, okay? Remember, your age matters, your language skills matter. So if you are not great in English and every single thing was done in English and you did not have proper translations, you did not know how to properly represent yourself, you may want to document those things as well. The fact that you are not great in English, that may come out in your affidavit. You are going to have to do more if you have an unexecuted removal order than someone that does not have a removal order at all. So just keep that in mind. Just because someone that does not have a removal order gets their case approved before yours doesn't mean like your case is not the same thing. I always want to tell people that, like, each person's case is different. The reason someone got a removal order in one situation may be completely different from your situation. Maybe they have all this documentation ready to go and you still have to gather those documentation. It's okay. You just have to start from where you are currently at, okay? And if you would like help in this process, or if you want to see if you qualify, if you have enough to rebut the presumption, feel free to schedule a strategy session with me. You can do that by going to my website, lilylegal.com, and clicking on Contact Us. And when you click on Contact Us, you can actually pick a date and time for us to speak and figure out what we need to do to make sure that you present a strong application for this parole, especially, like I said, if you have an unexecuted removal order, because that is going to really make it hard for you to get it unless you really put in the work on your case. As far as if you have executed removal order, like we said before, an executed removal order makes you automatically ineligible. Okay, so keep that in mind. Do not apply without talking to a lawyer first to just confirm whether you can actually qualify for it. If you can't rebut your presumption, things like that. Okay, but just wanted to do this live because I know this is new. We just got this information this week. If you didn't watch my live on Monday, please go ahead and watch that. I really do go through and break down all the requirements from the Federal Register because, again, I like giving you all the details. So we went through all of the details, including the criminal ineligibilities and things like that. So go ahead and watch that. And then this video is really just to make sure that you know this particular requirement for deportation orders, because it is something that they carved out and they are very serious about this, okay? Next week, we're going to be talking about the criminal cases, right? So if you have a criminal conviction, what does that look like for you applying for this? Because some criminal cases are going to make you ineligible, just like having an executed removal order is going to make you ineligible. So you really want to tune in next week where we're going to talk about that. If you have any questions for me, please go ahead and put them in the comments. I know that was a lot of information, but I always want to give y'all everything I got, because the more information you have, the better decisions you can make for yourself and your families. Okay, so I see a question from Instagram from Euphoria Dow 77. Trying to bring my fiance from Zambia on a 90-day visa. So I'm guessing you're trying to apply for a fiance visa. Feel free to schedule a strategy session with me so that we can talk about the requirements and all of that. And I also have a video on my YouTube channel where I go through the requirements for the fiance visa, comparing the fiance visa to a marriage-based visa, and helping you kind of figure out what the difference is and the pros and cons of each while you're making that decision. Okay. But in general, if you and your fiance have seen each other within the past 2 years, you can file a fiance visa application if also you two are free to marry. So you two, if either of you have ever been married, you want to make sure that that marriage has ended, legally ended, before you start the fiance visa process. Those are the biggest requirements, is seeing each other in person and being free to marry. And of course, documenting your relationship. That's really important. Documenting how you communicate. Because again, if you're in the US and your fiance is in Zambia, the chances of you two having, bank statements and things like that together is zero. Okay? Is zero. And that's okay. USCIS understands it, the embassy understands it. They just want to make sure that you two are in a genuine relationship and that you two are planning on building a life together and getting married once your fiance comes to the US. So, like I said, if you would like a consultation with me, you can schedule a strategy session. It's a free 15-minute session where you get to talk to me about your situation and I tell you what you qualify for and how I can help you with that process. All right. So I don't see any other questions. So just a quick recap. If you have an unexecuted removal order, meaning you have a removal order and you never left the US, okay, after you got that deportation order, you never left the US, you have a presumption that you do not qualify for the PIP. But you can present documentation to overcome that presumption. If you have an executed removal order, meaning you got a removal order, a deportation order, and you left the US or the US government took you out of the US, you now have an executed removal order, which means you are not eligible for this program. If you have a permanent bar because you had a removal order, you left the US and then you came back without inspection, if that's the reason you have a permanent bar, you automatically do not qualify. But if you have permanent bar because you entered the US without inspection, you stayed for over a year and then you left and then came back again without inspection, that means you have a permanent bar. However, there's no automatic ineligibility. You can still apply and it's up to USCIS in their discretion whether to approve your case or not. Just make sure you include documentation to basically tilt the scale in that discretion, right? It's their discretion and you want to present documentation to them of your life and everything else to show that you warrant, right, that you should get a favorable exercise of their discretion. All right. So that is all I have for you today. I don't see any other questions. Remember, if you're watching this on the replay, ask me your questions, okay? Ask me your questions. And then next week, we are going to be going over the criminal ineligibility part of this whole thing, all right? Thank you all so much for joining me, and I will see you next week. Bye.